Tom, I'm sorry.
I think it's fair to, I'm seeing that too in the courts, that the courts are getting more sensitive now to, generally speaking, I mean, notwithstanding Escobar, they're getting more sensitive to the fact that there are often reasons that the government declines to go forward with meritorious cases. And one other factor is just simple risk analysis. You know, if the government having as many cases as they have to do triage. They have to choose which ones to put our resources into, our scarce resources. And they may not be willing to take on a case where it's a new legal theory or a challenging set of facts to prove, where it's a 50-50 call as to whether they're going to win, as opposed to, you know, taking on the ones where it's a 75-25 call as to whether they're going to win. Whereas then we might think, you know, hey, if we win, it's well worth our while, so we might take that 50-50 case forward.
Rob, but if the government declines to intervene, but the case sits for, you know, 10, 12 years like the McBride case does, and there's been no change in the government's view of the underlying contract, they're continuing to pay on the contract, or they haven't changed their conduct, what does that do for you as a relator's counsel if you're trying to proceed with that case?
Well, you know, we talked about this morning. I had a case involving an agency that where they had made an award. They had made 2 awards, and my client challenged the propriety of those awards, thinking that they were induced by fraud. And we brought it to the agency's attention while there was a 3rd award pending before the agency. And the agency put that 3rd award on hold for a year while DOJ and the agency looked into the allegations very thoroughly. And the question really was how the agency was treating these situations. And at the end of the day, DOJ told me they were declining, and did decline. And then we were going through the process of figuring out what to do with the case, whether to take it forward or not. And I will say we were leaning towards not taking it forward at that point. But then while we're leaning, and trying to persuade a client who's got nothing better to do than to make us take it forward, trying to persuade them that it was really not worthwhile to pursue this, the agency went ahead and granted the 3rd award. So they, knowing full well what the facts were, went ahead and not only, you know, didn't do anything about the first 2 awards, but granted another identical situation. They're paid in the mine run of cases, right, knowing all the facts. So we, at that point, were able to persuade the client to ditch the case, as it should have been.
Tom, one of the arguments that the government relators have made is materiality is fact-intensive, and notwithstanding what the Supreme Court said about materiality is something that courts can decide at a motions to dismiss stage or summary judgment stage, that, you know, really defendants shouldn't be allowed to bring materiality, motions to dismiss based purely on materiality at the outset. What's your view on that?
Well, I think we accept what the Supreme Court said, which was, yes, you can have cases dismissed at the motion at the pleading stage before you get into discovery, when the facts are as obvious that the government has known about what was going on and then decided to dismiss the case. I'm trying to go back to look at the slide where these cases that you list on slide 17 show that where the courts have decided that you can dismiss cases at the before discovery is done, because you can look at the government's action, because the ultimate decision, if you get into discovery, is going to be, well, what did the government do? And if you can show what the government did in response to being aware of the allegations, then it's the defense hope that they won't have to engage in a lengthy and costly battle surrounding discovery if they can establish at the beginning that we can skip everything else about whether there's theoretically falsity if we can establish that it wasn't material to the government's decision.
How are you able to get that at the motions to dismiss stage when traditionally the courts are supposed to stick to the 4 corners of the complaint?
Well, I think, again, going back to, I think courts like to be they like to look at things holistically, and I believe, it depends on how the relator has pled the case. If it allows you to demonstrate that that even as pled, they cannot establish materiality. So I think it relates to that as well.
I can give you an example. So we screen a lot of cases for every one that we take, and very often the case that comes into us, someone calls us and says, I've got this problem. There was this contract that had this shenanigans in the bidding, and it's not just the opponent who got the bid, but it was the government folks who were in on it too.
Oh, mm-hmm.
They were all in on it together. And if I were to take that case and plead it honestly, I should get tossed out of
you would plead
the motion to
knowledge,
dismiss.
Right.
So.
But what about like a bribery allegation? I mean,
That's the saving grace, but that comes along once in a blue moon, where you actually have the evidence of the cash transaction or that's very hard to find.
But if you have a bribery allegation, going back to the Supreme Court's decision in Escobar, you don't have a specific representation about the good or service. If the government gets what it's contracted for, if it's gotten the product, if it's gotten the service at the price that it contracted for, do you have an implied false certification claim under Escobar if the only allegation is bribery?
So I have a thought on that. I call it the "oh, come on" situation. And I'm not being critical, obviously. It's a perfectly good question. But I think that the triple canopy case, which is one of the government's favorite cases, and it's one of the few circuit court cases that have actually broken the government's way. I must admit that, but still, where, as Chris has summarized earlier, the situation was that, the government was supposed to be paying for guards who could shoot weapons, and they couldn't. And in the wake of the the Fourth Circuit, I think reversed the district court, and then Escobar came out, and it went back to the Fourth Circuit, and Triple Canopy took another shot, incredibly, at this. Well, pun intended. Yes, totally intended. Yeah. Sorry about that. And the argument was, well, there were no specific facts that were disclosed, that this wasn't a half-truth situation, because it was sort of like, I'll call it, borrowing from real estate, a quit claim, where just like nothing. This is we're submitting a bill for the services. That's it.
Right. It listed a number of people who performed the work and the hours that they spent.
Yeah, totally accurate.
Right.
Well, maybe. I mean,
right.
We'll assume that was accurate. Meanwhile, as I think Tom, you may have pointed, they're falsifying the cards, and the shooting range results and all that stuff. But that wasn't disclosed. So it's not like we're submitting this claim for this number of hours for this number of guys who all shot well at the range, or who went to the range, but they're not. So there's like no facts. And my view is that the circuit court looked at that argument by Triple Canopy and said, you must be kidding. Oh, come on. I mean, the government was supposed to be paying for people who could shoot straight. And you're getting hyper-technical in applying Escobar and saying that, the only way under an implied certification theory you have a case is if it's a half-truth because you've disclosed some specific facts. Now, in my view, and if you read the decision, the court specifically as well, there was a half truth, but I think that's a little bit of an artifice, because
right. I agree, but I mean, that's why I say I think the outcome makes sense, because the government paid for something that was at base fraud, and so they had to figure out a way to reconcile it with Escobar. So they said, when you submit a claim that says you are seeking payment for a guard, that implies that the guard knows what they're doing and can shoot a gun, and therefore, there is a false certification.
Yeah, and frankly, that's what we're talking about. I think is criminal conduct that could. I don't know what happened criminally. I don't know if that was charged or investigated. I don't know, but it's kind of it seems like a potentially obvious criminal case to me. and yet the defendants suggested it was not even a civil case. You know, it just doesn't work for me. So, but yes, there is this notion that that for implied certification under Escobar, there has to be a disclosure of specific facts. I know, and I think everyone in this room knows this, but I will say that the Supreme Court in Escobar said, we need not resolve whether all claims for payment implicitly represent that the billing party is legally entitled to payment. I think that's, you know, I think there's language in the statute, whatever exactly that means, I think there's language in the statute that suggests that, you know, depending upon the circumstances, the Supreme Court might have some additional views on the scope of what can be an implied certification-based false claim case.
I think it's just worth throwing in that my firm just got a decision yesterday from the Southern District of New York in a case where we actually lost on that point, on the point of whether or not the Supreme Court has left it open for other circumstances. It was a government-intervened case, so the government actually was the one submitting the briefing on this and argued, of course, that in these circumstances, just the mere submission of the claim where there was an underlying material violation of a statutory and regulatory provision that would have precluded them from getting paid for this should have been enough to trigger an implied certification theory of liability. The court said no, but the court said, but you have pleaded and do have a fraudulent inducement claim, so you therefore can go forward under the False Claims Act. So, you know, I think what Richard was just hinting at is that, you know, there should be in that circumstance at least another theory of fraud, which is that you have expressly made false statements in support of a false claim, namely the falsification of the guard records supported your false claim that you made, which, you know, so there should be a handle for liability, even if a court decides to go the narrow route on implied certification.
You know, the Supreme Court didn't expressly talk about this in Escobar, but fraudulent inducement theories still require materiality. So, Tom, in your view, you know, would the same analysis apply in terms of materiality for another theory of liability?
I think it does. I think actually the Escobar opinion didn't cabinet itself that the materiality analysis is linked solely to implied certification cases. So you know, I think Escobar has something for everybody, whereas defendants will say it's a rigorous standard, it's something that has to be overcome by a relator, and I think the government's, I'm not going to speak for the government, but I think the government's position is, you know, and you even referenced this before, Rich, that the materiality standard is whatever the materiality standard is in the statute, you know, likely, you know, to affect the decision-making process. So I think whatever the materiality standard is in Escobar, I believe it's something that, you know, defendants would use to say, hey, if you don't meet this heightened standard, regardless of the theory of liability under the False Claims Act, that it would still apply.
You know, as I listen to this, and I listen to Rob, I listen to Tom, and I think about other theories like fraudulent inducement. You know, part of the menu that Escobar set forth on materiality includes whether the conduct or what's at issue goes to the essence of the bargain between the government and the contractor, the putative defendant. And I think when I think of fraudulent inducement, I think you're talking about of necessity. It goes to the essence of the bargain. I mean, it kind of makes it almost easier. You're not dealing with, well, you know, whether one widget in the helicopter met specifications or sort of met specifications, or you know, but you're dealing with basically the whole ball of wax. I think there's a certain irony in that, though. And that is, for the longest time, I think up to Escobar, there was this notion there were two worlds after Mike's, you know, conditions of payment and then conditions of participation. And I think when I think of fraudulent inducement, I think in a lot of instances you're talking about the very question of whether there should be if it's a program, whether the entity in question should be allowed to participate, and that's the essence of things. So I think there's a certain irony there.
Well, but that's actually another, I'd say, significant part of the Escobar holding, is that they kind of ridiculed the distinction between conditions of participation and conditions of payment, where they said, you know, defendants point to the idea that this was actually a condition of participation and therefore should not be actionable. The violation in Escobar was a violation of something that was a condition of participation in the program. And they said, well, of course, that's absurd, because if they can't participate in it, they can't be getting paid for it. You know, which was the right approach, I think, and
But it took 15 years or so
it
to get
did.
to that point.
And since my case yesterday, the district court's decision, you know, we're talking about a court within the Second Circuit, they really were talking about a condition of participation, which, so this, in the pre-Escobar world, we probably wouldn't have come out with that ruling, and yet we got that ruling. So, you know, Escobar worked both ways.
Tom, if the government has knowledge of allegations, but they haven't run them to ground, or they never choose to run them to ground, so they don't actually know whether there's been non-compliance or not, what's your view as a defense practitioner, you know, trying to file a motion to dismiss or a summary judgment motion?
I think, so whether the government, so I think it goes hand in glove with the materiality analysis. So the government, if the defendant, and this happens, you know, where you represent people and they say, hey, we think we got a problem, you do an investigation for the client, you tell them, you should tell the contracting officer, hey, there's this allegation, we're looking into it, that's enough to put the government on notice that there's a potential problem, which is, you know, that's sort of the, you know, it goes to a knowledge element of it as well. But if the government knows but continues on and doesn't take any steps to conduct an investigation, I think you're there at the same argument to say the government was aware, and here's what the government did in response to the allegations, which was take action or take no action, whatever the facts end up being.
And Rich, from your view, I know you're talking about, you know, trying to find the right person, you know, who's the right person here, you know, but if there are people who, you know, are the right people and they hear about it, but they don't choose to do anything, or they, you know, sit on it, or, you know, they get busy with other stuff, how does that affect your view going forward with the case?
Well, you know, just my view, the first thing is I'm wondering if the Inspector General for that agency is looking at what these folks are doing. Truly. I've had those thoughts over the years without getting specific. But that's a case I probably don't want to pursue, in a nutshell. You can talk, and I've already droned on sort of on the subject. It's a case I don't want to pursue. Mm-hmm. You know, if it's a very low-level person, okay. If it's someone who's acting clearly ultra-virus and maybe it's a bribery situation,
yeah, sure.
Different story altogether for everyone. But no, you've outlined a case that the government, that I would recommend declination on.
Okay. In terms of practice thoughts, you know, for folks in the room who, you know, are representing clients in False Claims Act situations, you know, Tom, from your perspective, what would you be telling clients from a compliance perspective after Escobar? What kinds of things should they be doing?
So you know, a lot of the cases, as you know, I'm sure you're aware, we get a client will call us and say, we think there's a problem, we'll do an investigation. We conclude, based on our review, that there's no problem, that there's no disclosure obligation to tell anybody in the government that there was a problem. Our advice now factors in, you know, if there is no issue, you may as well disclose it to the government, because you'll have an opportunity, God forbid, that there's a disgruntled ex-employee who's going to look at the same fact pattern, who was interviewed during the course of it, understanding that someone's looking at it, and then they're going to file a key TAMP case. That you're better off disclosing whatever the issue was, because it's immaterial, right? So you disclose the immaterial so that you can say later on that the issue was disclosed.
Going to one of the things Rob said earlier, what if it really is just a regulatory issue, and you have someone within the company who's saying, well, I think there's a regulatory problem, and you're looking at this and saying, well, it really doesn't seem to be material to the False Claims Act, the government really shouldn't be doing anything, are you prepared to walk a client in on a regulatory violation?
I think, so again, I think it depends on the relationship the client has. I mean, many of the clients that I represent in the, even in healthcare, but mostly in defense contracting, they have a good relationship with the contractor. So the contractor has a good relationship with the Navy, or they have a good relationship with the Army, they have a good relationship with the Air Force. You can have a discussion at a high level, because the people at the level where they'd be worried about regulatory violations will see the big picture. I think in most instances that they'll be, rational actors as opposed to the unreasonable or the non-objective reasonable person standard.
Rich, from your perspective, what are you seeing in the year after Escobar? Are you seeing more companies, more potential, defendants, contractors coming in?
The short answer is no. Probably a lot of folks are familiar with the notion that if one comes to the government with a potential problem, even one that might meet the standards of false claims, by statute, you can reduce your exposure to double damages, and various agencies have official or unofficial voluntary disclosure programs to which a defendant can be admitted. I don't think it's done enough. I think more of it should be done. I think that folks who are trying to game it and figure, well, if I don't disclose this, what are the chances of someone, a whistleblower that might come to Rob, finding out about this and then disclosing to the government, or what's the chance that the government, so I think that for those who are, playing that game of roulette, it's not a particularly good idea, especially if you're talking about high stakes. Often I've seen cases where a defendant will say, well, that wasn't our interpretation of the regulation, and they built millions of dollars, hundreds of millions of dollars. And call me naive, call me a government guy, but one of the first questions I asked was, well, did you ever discuss your interpretation of that regulation with the agency? That's a little bit different than disclosing the matter to the U.S. Attorney's Office. But did you ever try to play it straight, or were you just trying to game it? And it's not a good thing when I see a case where I have a sense that the company, the putative defendant, was trying to game it. They may still persuade me that there's no False Claims Act case, but I don't like it when people, and I think courts don't like it either for the most part, when there's a sharp practice in government programs or in government contracting. So I think strong compliance programs are very, very good idea. And if you've got a strong compliance program, you have confidence in your program, you should feel that you can put your cards on the table with the government and have that dialogue.
Let me ask you, in terms of that hypothetical I gave to Tom, you've got it's not a clear-cut False Claims Act issue, but it's a regulatory issue, and you're thinking, somebody could potentially bring a claim, but it doesn't seem like it would be a really reasonable one under Escobar. Who should the disclosure be made to? Should it be made to your office? Should it be made to the agency? In terms of trying to get the appropriate level of credit?
So it's a good question, because I've been doing this stuff for a while, but I still see cases alleging frauds in connection with government programs and I just don't know the program. I think in the first instance, it's sort of like exhaustion of your remedies. You should go first to the regulating agency. Mm-hmm. That's my suggestion, and document it. If there's an agreement, then get that agreement out in the open. I just think that when that case is ultimately presented to my office, you're as a regulated entity, that might be caught in the crosshairs of a quitam suit that might be filed, you're just in a better position if you've gone to those folks at the agency to whom deference should be given in the interpretation of their regulations.
Yeah, they're actually, in the procurement area, there is the mandatory disclosure rule. So it's part of the regulations, the FAR, where you have to go to the contracting officer and to the Inspector General's office. And then the Inspector General's office will forward a copy of that to the Department of Justice Civil Fraud Section, one of the assistant directors there. And so that's just, so that's how you would do it in the procurement area. In the healthcare area, I guess if you've got certain potential violations, you're going to want to go to the HHS IG. If you've got stark violations, you wanted to go through the voluntary disclosure protocol that they've set up for that. I think that's still in existence, that voluntary disclosure protocol. But so there, and yes, I having actually been on the other side of one of those, I have seen how when you get in the door and you make a full disclosure and you're willing to take the regulatory rap, it just completely changes the tenor of the conversation if down the road somebody comes in and tries to blow the whistle on that same activity that you have already disclosed.
Rob, let me ask you, since Escobar, what considerations are you giving, if any, to how you're pleading, how you're drafting a complaint? How's that affected your thinking?
Yeah, that's a good question, because of course a whistleblower knows nothing usually about what the contracting officer is thinking or would do. What we do know is what the defendant was thinking. And so we're alleging, typically, if we have the access to it, the defendant knew that this was problematic, if we have the access to that, or that the defendant was reckless in not knowing. But then we're adding that, of course, it's a pricing thing. It goes to the benefit of the bargain. We zero in on that part of Escobar. It goes right to the heart of the bargain. They're misrepresenting price, and of course, that's material. Or whatever else it is, it goes to the heart of the bargain, and of course, it's material.
So are you trying to allege additional theories like fraudulent inducement as well as the implied false certification?
We've always alleged other things, because the implied false certification, we on our side have never really accepted as a valid theory as much as a construct of, that the defendants have foisted on the courts. You can make pretty much any implied false certification case, if you look hard enough, including Escobar, into an express false certification case. They expressly misrepresented through their submission of the billing statements that they were billing for these particular services. Or you can make it into what we call A1B now. It used to be an A2 claim, false statement in support of a false claim. Right. Things like that. So we'll always be going in another area, but we will have to come back to materiality ultimately and say that this mattered. That we've always had something in our complaints to the effect of, if the government had known about X, they would not have paid the claim. It was a condition of payment. In some form, we're going to say that. And why would we have said that 20 years ago? Because we have to show that the misconduct caused the damages. So if you can't plead the causation of the damage, if you can't say that this had a consequence, then you're talking about a civil penalties case, which is probably not worth bringing.
Mm-hmm. Rich, how about in terms of your perspective on pleading these kinds of cases post-Escobar?
Well, I think it's a lot easier for the government than it is for a relator, as Rob was just outlining. We're going to find that reasonable man in the government. We're going to find that contracting officer or that program official who had a dialogue with the defendant and who said, well, in these emails, I made it very, very clear what our view of the regulation or the contractual provision was, and the other side, knew that. So I think that, I would like to think that it's not going to be too difficult on a going forward basis, in filing out complaints and intervention, or just out complaints where there's no qui tam, but to sufficiently allege materiality. I do think, though, that frankly, when it comes to motion practice, notwithstanding footnote 6 of Escobar, I do think that the question is one that's better suited for summary judgment than for 12b-6. I recognize that, defendants will take their shot. The Supreme Court has given the green light, right? So that's fair. But I just think it's a better issue once there's been some discovery. Of course, that gets into, as Chris was pointing out, I forget which case it was, where the discovery just went on and on and on.
Yeah, it was McBride, right?
McBride, and I could see how that, if you've got years of discovery can cost millions of dollars too, especially if it's a big document case. So certainly I can see why folks would take a shot. I just think it's a better issue because it's so fact imbued for summary judgment.
Tom, what are your thoughts?
So I think, it's interesting, the cases, again, that you showed that were resolved on motion to dismiss, it goes, those cases were pending for a long time before they ever got to that phase, right? So I think it's hard to, while the Escobar opinion leaves open the opportunity to file a motion to dismiss it early on in the case, those cases were pending for a long time before those particular courts of appeals said, yes, we're going to dismiss those cases.
Right.
So I think I think what ultimately is going to happen, it's going to be harder to get cases out on motions to dismiss early on, and then it's going to become costly discovery. And I wouldn't be surprised if at some point the government starts modifying its contracts or its standard forms, its DD-250s, whatever they are, that say every one of these claims for payment are material to our decision to make a payment, right? Something along whatever the language is in order to.
But wouldn't the Supreme Court say that kind of broad language really isn't going to be enforceable or relevant from a
They would say it, but it's also not supposed to be relevant whether the government intervenes or not, and that apparently, that's an issue that they look at as well.
Yeah.
So I think while the opinion says it, I think maybe it's a bootstrap argument that allows, when the government starts modifying how it contracts with people, that it's going to, it's going to have an effect, is my guess.
I can add two things about the Escobar case in particular. One was, the government submitted a brilliantly done brief in the Supreme Court. Charles Scarborough of the Civil Appellate Division wrote that brief, and starting out with the fact that one of the prime examples in the False Claims Act, the original False Claims Act, 1863, that's in the legislative history, was about the gunpowder that was sawdust and the milk that was rancid, And he pointed out these were all, and what we used to call at DOJ, defective product cases. These were all what defendants would now call implied certification cases, because you didn't say that you were delivering, gunpowder that actually worked. You just said it's gunpowder, and it was something.
You would never be so stupid as to say that.
Or milk that actually wasn't rancid. Right. So it was always something implicit in the representation of what you were putting forth when you asked for payment. Number one. Number two, when the government was arguing the case in Escobar, and they were specifically asked, the solicitor was specifically asked the question about, would you take the position that if the contract had a provision that all of the staples used in the contract had to be purchased from American suppliers, and that was violated, would you take the position that that was a condition of payment? And when he said something along the lines of yes, there was a gasp in the courtroom from everybody, especially my side, and that was just one of those things that you wish you could have just pulled back,
Now, if given that discovery can be so expensive in these cases, if a defendant has raised, a viable argument about government knowledge, audits or other issues like that, and it gets past a motion to dismiss, Rich, would the government agree to bifurcate discovery and allow discovery on government knowledge and conduct before getting into all of the other really expensive stuff?
Possibly not, because we might just think it's inefficient.
Because the government's always concerned about efficiency.
That's an obvious thing. Any newspaper will tell you that every day. But we'd listen to the point. We because the flip inherent to that suggestion would be the fact that we could move an aspect of the case quickly. Because all the other stuff, quantifying the claims, that could legitimately take a company a while to get that information corralled. So we would listen to it. Anything that's going to move these cases faster and make them more manageable is a good thing, because if they're worth a lot of money, they're hard to manage.
Rob, from your perspective, a case the government has declined to intervene, same question to you. Would you be willing to consider that kind of a bifurcation?
Bifurcation where the first question is materiality?
Yeah, going to materiality?
I don't think I would probably agree to it in the terms that the defendants would likely propose, because, I think one thing I would counter with, if they said, let's agree to take the deposition of the contracting officer, I would say, well, wait a minute, I want to take some depositions and do some document discovery to determine whether or not you knew the contracting officer was an idiot, said so, the unreasonable person, and said, but we can get away with this even though it's wrong. The memo that every once in a while is out there.
I take umbrage at the notion that there could possibly be a government employee that could be characterized as an idiot by anyone. But
right. So
sounds like a diminished capacity defense.
There we go.
So I doubt we would consent to the kind of proposal that would be made.
Okay.
But the proposal does make a lot of sense if the prong is materiality, and discovery can't be costly, but if the discovery is a burden on the government.
Yeah, but typically in these cases, there's stuff that the defense doesn't want the plaintiffs to know, that they're only going to learn through discovery, and there's stuff that the plaintiffs don't want the defense to know because they're only going to learn it through discovery, and that would include, how sometimes, in certain cases, how bad the contracting officer really is. So I think the chances are we would not be looking on those favorably.